Welcome to the Denison Forum podcast. This is Dr. Mark Turman, Executive Director of Denison Forum. We're glad to have you back with us today. We have a special opportunity of conversation. We're actually recording today at Dallas Baptist University, one of the really fine jewels of the Dallas-Fort Worth Metroplex, situated right in the middle between Dallas and Fort Worth, easily accessible. If you don't know the Dallas Baptist University story, we hope that you'll check it out and that you'll consider sending your students here or becoming a student here, one of the great treasures of this part of the world. I'm here again today with the CEO of Denison Ministries and the cultural apologist for Denison Forum, Dr. Jim Denison. Jim, how are you today?
Doing well. Mark, how are you?
Doing great. I know this place is special to you and that you spend a fair amount of time at Dallas Baptist University helping out in various ways.
I love DBU. God's hand is on this school. The former president, now Chancellor Gary Cook, is one of the best friends I've ever had. And I just am so grateful for how God's using Gary and the current president, Adam Wright. What God is doing through DBU is absolutely transformative. And so I teach in the doctoral program here, speak in chapel a lot, serve on the board, and just could not be more grateful to be on the campus and to be in this conversation, especially today.
Our first guest on the Denison Forum podcast is Judge Kenneth Starr. And for those unlikely people who haven't heard of Judge Starr, let me just give you a little bit of his background and resume, which is impressive beyond words. Judge Starr has argued 36 cases before the U.S. Supreme Court, including the time when he was U.S. Solicitor General. He served as United States Circuit Judge for the District of Columbia Circuit, as Counselor and Chief of Staff to U.S. Attorney General William French Smith, and law clerk both to Chief Justice Warren Burger and Fifth Circuit Judge David Dyer. He was appointed to serve as independent counsel 5 times, including perhaps the most well-known, the Whitewater investigation from 1994 to 1999. He has served as president and chancellor of Baylor University and the dean of Pepperdine School of Law. For 25 years, he taught constitutional issues as an adjunct or visiting professor at 5 law schools. He has served as a partner at 2 national law firms. He continues to serve on the Board of Advocates International, the Supreme Court Historical Society, and the Christian Legal Society. Throughout his career, he has championed the cause of religious liberty and freedom of conscience for all persons. He has an undergraduate degree from George Washington University, a master's degree from Brown, and earned his law degree from Duke University Law School. Judge Starr is also from Vernon, Texas, not far from where we are today. I was interested to find that out, and I'm really intrigued to know why it was that you had to sell Bibles to door to door. I've gone door to door talking to people about church and faith issues. I've never tried to sell them a Bible. Is there a story there?
Yes, and I tried to sell those Bibles and did a fair job. Not great. I didn't change careers outside Cincinnati, Ohio. And it was really wonderful to try to sell the King James Version of the Bible, which was the family Bible that we were using, to our Roman Catholic friends. I actually sat down with a priest at one of the local parishes and just tried to explain this. Look at these nice pictures here.
Right.
This overcomes all kinds of denominational and cultural rifts and so forth. I went back to college and stopped selling Bibles.
Well, we want to thank you for sitting down with us. You're going to do a presentation a little bit later this evening at Dallas Baptist, and we just are grateful that we were able to catch a little bit of your time and for you to sit down and have a conversation for our listeners through the Denison Forum podcast. Thank you for that.
Well, thank you. I'm very pleased to be here, and I'm honored to be here with Jim, with Dr. Denison. It's just a great privilege. So thank you. And it's a blessing to be at Dallas Baptist University, which I know and love well. I came to really admire Dr. Cook. Mm-hmm. And then his successor, Dr. Wright, when I was called to serve at Baylor University. So it's a homecoming of sorts for me to be back on this beautiful campus. So you're quite right. send your students or come yourself. It's a wonderful
Absolutely.
institution.
Yeah, my friends at Baylor and at Howard Payne will be a little bit upset with me for saying that, but there's lots of good options.
Well, if you live around Brownwood, just stay right close to home.
Exactly.
But if you live in the Metroplex especially, here you are.
That's right. It's a good place, great place. You've recently written a book called Religious Liberty in Crisis. We're also going to talk a little bit about Dr. Denison's book, The Coming Tsunami, that we've been featuring through the Denison Forum. But I want to dive right in to this conversation about religious liberty by getting you to react, Judge Starr, to a quote. I'm sure you're familiar with the attorney and journalist David French. I heard David French say recently about religious liberty in our country. He said, "Today, the attacks on religious liberty are many, but the wall is strong." In your book, you talk about religious liberty in a lot of different ways, some of them very concerning. But you also have a great sense of optimism and hope about religious liberty. Why do you say that in the midst of a culture that is so hostile to so many things, especially things of faith?
Well, and Dr. Denison, in this wonderful book, it's a troubling book, but a must-read book, The Coming Tsunami, points to these cultural events that are unfolding. They are crashing around us like large tsunami waves on the sea, and they're very troubling. Here's the good news. There is, in fact, a seawall. The seawall is the Constitution of the United States and the Bill of Rights, in particular, the First Amendment. And those majestic first 16 words, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Before you get to freedom of speech, before you get to freedom of the press, before you get to the right of the people peaceably to assemble, to petition the government for redress of grievances, you are in the land of the religion clauses, the first freedoms. And the Supreme Court of the United States, after having wandered through the wilderness of separation, strict separationism, we all believe that church and state have to be separate. But exactly what does that mean? And some of the interpretations of yesteryear were very concerning. What the message I try to bring in the book is, over time, the Supreme Court of the United States in particular has identified what I call the great principles of religious freedom, and they stand as bulwarks to protect the fundamental religious liberties that we all should enjoy.
And that's really what that simple phrase, the great principles, is really what I keyed on as I read through your book, is just what those actually mean and how strategic they are for us. Dr. Denison, you wrote in your book, The Coming Tsunami, an entire chapter about the Equality Act and concerns around that as it pertains to religious liberty. Give us a brief description again of the Equality Act as you understand it, and we'll ask Judge Starr to react to the probability of it becoming law. What if it does become law? What happens to it possibly from a judicial standpoint?
And I'll be so interested to hear his thoughts in that regard. And part of what I've been given to believe from experts that I've spoken with on the subject are exactly in alignment with what the judge just said, that at the end of the day, the First Amendment is our friend, even with regard to the Equality Act. And Judge, I'll be interested to see how you're feeling about this, but I've heard people say that the Supreme Court, if it gets there, will actually strike it down if it gets that far, just because it doesn't pass muster with the First Amendment and so much other jurisprudence. But the so-called Equality Act amends the 1964 Civil Rights Act to prohibit discrimination on the basis of sexual orientation and gender identity. And this is crucial. It also forbids any appeal to the 1993 Religious Freedom Restoration Act. So what that could mean in principle, as has been explained to me by those at Alliance Defending Freedom and other places, is the possibility, here even at Dallas Baptist University, let's say, DBU has a very strict, very biblical code of conduct that it expects of its staff, let's say of its faculty and its staff, as regards defining marriage, for instance, as a covenant between a man and a woman. Let's say the Equality Act somehow became law. Let's just say that. Let's say that we have someone on the faculty here who is marries someone of the same sex, and they are dismissed from their position as a result of their violating these codes that they agreed to when they came onto our faculty here. Let's say that they sue us. Let's say a judge issues an injunction. If we don't obey the injunction, it's been said to me, someone could go to jail. Could be criminal penalties for a civil act here, perhaps down the way. Whether it gets to that place or not, what's behind it is a very clear cultural move that sees my opposition to same-sex marriage as being identical to my unwillingness perhaps to marry an Asian couple or a Latino couple or an African-American couple. The confusion here is the belief that I am a white supremacist or a KKK member in exactly that same construct, There was actually a senator when the Judiciary Committee was debating the Equality Act last year who made that exact allegation. That somebody like me, with my position relative to same-sex marriage, is identical to a KKK member burning crosses in front yards. So there's a larger cultural move in play here as well, which explains why the Equality Act has passed the House twice, why the president says he would sign it if it made its way out of the Senate. I'd be fascinated to know what the judge thinks about the degree to which that could happen, whether it would pass judicial review, and what he thinks about it as well. But that's my understanding.
Judge Starr?
We're all in favor of equality,
Yes.
equality under the law. The idea of all persons being treated equally under the law is so vital to who we are as a free people. But the Equality Act trenches on freedom of conscience. And let me stick with what Dr. Denison very well described as a DBU at Dallas Baptist University hypothetical. Here, the Supreme Court, with the wonderful and great principle of autonomy, rushes to the rescue to pull us out of the waves that have engulfed us in the tsunami. And let me use a real example. This is from the Supreme Court of the United States about 10 years ago. And I'm pleased to say that the case I'm about to describe, it's a very human case, was unanimously decided by the Supreme Court. This was not a 5-4, 6-3 squeaker. Unanimously, including Ruth Bader Ginsburg, the Supreme Court in a case called Hosanna Tabor involving a church school dismissed a teacher who had threatened with some pretty good reasons to bring an action against the school for its treatment of her, and she was suffering from a condition called narcolepsy. You fall asleep. I find that my audiences, Dr. Denison, like you, tend to suffer disproportionately from that particular malady. So she knew she couldn't teach, but the question was, after a few months, was she healed? Was she restored? And she said, I am. Here's my doctor's message saying all is well with Cheryl Parrish. So she wants to teach, and the school says no. They have a dispute over it. She says, I'm going to go to the Equal Employment Opportunity Commission, the EOC, and file a complaint. And they said, the Apostle Paul wrote the church at Corinth that we don't do that. We resolve our disputes, hopefully amicably and peaceably, but we don't go to the magistrates to do this. Off she goes to the EOC. The school fires her. The EEOC takes her cause all the way to the Supreme Court. The Supreme Court of the United States, recognizing the importance of our civil rights laws, including Americans with Disabilities Act, stood foursquare in favor of civil rights laws, but not as applied in the context of a teacher who was helping convey the faith or transmit the faith. And what was that principle? The principle was one of the autonomy of religious institutions to chart their own course, to determine who their ministers, pastors, priests, and rabbis will be without the interference of the state. And this was it was the state meaning government. Without that principle, without that wall, that bulwark of protection, the Equality Act would be extremely dangerous. But with that protection, the idea of autonomy, I'm very optimistic that the Supreme Court of the United States would, by a significant margin, say, no, the Equality Act cannot override the religious objections of religious institutions.
Mm-hmm. We were talking about this a little bit earlier today. Do you think that would be, in cases such as the Equality Act, let's just assume for a minute that the Equality Act became law, do you think that there would be a long process for those kinds of things making their way to the court, so that there could be a season where believers, Christian leaders, pastors, presidents of universities like Dallas Baptist could be subject to persecution or even fine or other type of penalties while this was making its way to the court? Or would something like that typically find its way into a hearing in the court's eyes very quickly?
Not to the Supreme Court, and you're making a very good point in asking the question. Sometimes the wheels of government, including the wheels of the courts, grind a bit slowly. So yes, there may be some setbacks along the way. After all, in the Cheryl Parrish case involving Hosanna Tabor, the Court of Appeals ruled in favor of the EOC, right? And said, you win. And so we have to be prepared for those kinds of losses. In fact, it's humbling and at times dispiriting. We're to maintain a sense of rejoicing and optimism and so forth, and to be content in all things. But I am, shall I say, not particularly impressed with the quality of some of the decisions that come out of the lower courts. So the federal district courts and the courts of appeals, they wax and wane. So one of the great challenges is to get the Supreme Court's attention so that it will, in fact, look at these issues thoughtfully, carefully, and overwhelmingly rule in favor of religious liberty.
Right, and in the most timely manner possible.
That's a hope.
That's a hope.
It can't be, it's a prayerful hope. It can't be an expectation.
Right. I want to turn for a moment, if we could, to some of these other great principles that you talk about in your book and ask you to kind of unpack them a little bit for us. We hear them. We may have heard them in civics classes if we had them in high school, other classes through our education, but you talk about them so beautifully in your book. I wonder if you could unpack them. A couple of them, you talk about the distinction between a wall of protection as opposed to a wall of separation. What do you mean by that? And then follow along with that, the idea that the state must have a compelling interest to intervene in religious liberty matters.
Right, to justify an intrusion into religious liberty. The state, the government, has to have an overwhelmingly important kind of interest. Let me illustrate that, and then I'll come back to the first part of your question. An Amish business person said, I cannot in conscience participate in the Social Security system, so I want a judicially created conscientious exemption from the Social Security laws. The Supreme Court held, and I don't disagree with this, that no, we have to have a Social Security, the government has seen fit to have a Social Security system, and we cannot have taxpayers saying, no, I don't like this program, or I don't like this war, I don't like what we're doing vis-a-vis the Ukraine, whatever the issue might be, and therefore I'm going to withhold some of my taxes, or I'm not going to participate in these programs. So the court held the government did have a compelling interest in protecting the integrity of its Social Security program. There's an example of a cause that is so important in the views of the court that an erosion of religious liberty can occur. So it's not as if religious liberty claims always win,
right?
But they must, in fact, run the gauntlet, and not atypically, they survive, as we saw in the Cheryl Parrish case. They survive and they are victorious. So this is a very important caveat for people to understand, that the great principles are great protections. So let me now come to the wall of separation versus the wall of protection. As so many of your listeners know, the wall of separation is a metaphor drawn from Thomas Jefferson's letter as President of the United States, but it was a letter. He writes a letter to the Danbury Baptist Association, right. So a good Baptist group. And of course, the Baptists were rightly concerned. There was an established church in Connecticut at the time, taxes having to be paid to support the congregational clergy. There were different manifestations of the established churches. And Mr. Jefferson was very sympathetic with the idea of religious liberty for all persons, and he envisioned this metaphor of the great wall of separation. But like any metaphor, it can be overused. So what does that mean? In an example that I think makes the point that I discuss in the book of legislative chaplains. One can approve or disapprove of taxpayers' money going to legislative chaplains, but is it unconstitutional for the Congress to have a legislative chaplain paid out of taxpayer funds? Is it unconstitutional to build a beautiful chapel at the Air Force Academy. The examples are so legion. You cannot have an impermeable wall of separation between ecclesiastical activity and the activities of the state. And the Supreme Court upheld the idea of legislative chaplains based upon the strength of history and tradition because of that's one of our walls of protection. If you try to tear down some of our iconic take "In God We Trust," the Supreme Court of the United States will rally around and say, no, that is protected by history and tradition. But if you say, but wait, doesn't that violate the wall of separation? Well, the wall is not exactly like the Berlin Wall of old, right, where you probably couldn't get around it. It's a different kind of metaphor that helps us understand that, yes, it's precious to have, as we just saw in the Hosanna Tabor example, of the state not interfering with the church activity, church decisions in terms of personnel and so forth. This is vital, but it's not an impermeable wall that you cannot ever surmount. So it has created, the wall of separation metaphor has created a large misunderstanding, which when one thinks about it for a while said, yeah, the wall can't be that high, the wall cannot be that thick, there has to be some give in the joints, some play in the joints, as the Supreme Court has said.
Because what I commonly hear in this is when somebody starts talking about the wall of separation, you start hearing a lot of anger and somebody wanting to contend for their position to draw this strong, strict separation between the two, usually because they don't like something going on, and they want the church out of something is typically, but it's become a part, Dr. Jim, if you could comment on this as well, is that become a part of the common vernacular of conversation, especially in the partisan divides within our country, is just this strong feeling of separation, and really in the idea of impermeable.
I think you're right. I think that's on two levels, as I've experienced it as a minister myself, as people that have been around evangelical ministry my entire career. On the one side, there are those that don't understand what the judge just said. They believe Thomas Jefferson's idea to mean that there can never on any level be a dollar of taxpayer funding or taxpayer time devoted to something that somebody could characterize as religious, or we have violated this separation of church and state wall. And so those that misunderstand the wall in that way then attack the metaphor itself. They'll attack Mr. Jefferson. I've heard pastors condemn this idea of the separation of church and state and the wall of separation and accuse him of all sorts of things. Well, we know that he was himself a bit problematic as regards his own religious views, his own particular theological constructs, as well as his issues relative to slaveholding and all of that. And so we get into kind of a character assassination sort of a move, and we want to withdraw this. We want to get to a theocratic sort of a move. We want to get back to a place where the church is controlling the state, as might have been the case in a medieval sort of a construct, where popes are naming kings and churches are controlling government. Well, theocracy is only good if you get to be theo.
Right.
And at the end of the day, if we're in a construct where the church is going to control the state, what we're going to typically find is the opposite occurs. I remember hearing years ago Chuck Colson saying when he was in the Nixon White House that the easiest group to control were the pastors. If they bring them in for a photo op with the president, they would then do whatever they wanted. And whenever the church tried to control the state always wound up controlling the church. So that's one extreme, is to get to a place where we try to tear down this so-called wall for the sake of church control of culture. That's not rendering to Caesar what is Caesar and to God and to Christ what is Christ, to God what is God's. That's not this two citizens kind of motif that Peter describes. That's not the right move. Then I've seen people go the other direction in evangelical tradition and get to this place now where we want to so withdraw from the culture, want so nothing to do with this pagan, secular, fallen culture. It's kind of Rod Dreher's Benedict option, right? Maybe even on steroids. This idea that the culture is itself so fallen and pagan that we want the separation to be so complete that we keep the salt in the salt shaker and the light under the basket. And when we're becoming Amish with our faith, as it were almost, then we're in no sense penetrating the culture. We're not engaging the culture as we've been called to do. So there's this balance, isn't there? Where on the one side, we're not seeking to control the state. We're seeking to be good citizens, as Romans 13 would suggest. We're seeking to pray for our leaders, as 1 Timothy 2 would say. As Justin Martyr said, my people make good citizens. John Wesley made the same point as well. We want to be moving in that direction. We want to be engaging the culture. We want to do so in a winsome way, not as culture warriors, but as cultural missionaries. And that balance is a case-by-case question.
Right. And live in this, like you said, two-citizenship world where we have a temporary citizenship here and a permanent citizenship in heaven. I wanted to move a little bit further. There seems to be in the culture and in the general mindset of many people the idea that when we finally get to the Supreme Court, we've landed in the area of the great purity, is what I would call it, the great purity. And we sometimes seem to forget that these justices are actual real people, and they have real life experiences, and they have real life brokenness. They are exceptional individuals, or they wouldn't be where they are. But they are a product of their own traditions and culture and background and expectations. Judge Starr, Jim, just weigh in this a little bit. How do we understand that they are a part of the culture? They are a part of the traditions and history. They don't stand apart from it so much as they are a part of it. And it is going to color the way that they rule.
Well, the task of a judge is to do the very best, Mark, that he or she can in setting aside all of those considerations. This is the way I was raised, or this is the way I was taught. Oliver Wendell Holmes put it very precisely in saying that that which is now here to us as truth may have caused people to fight not so long ago, right? That we need humility, and judges in particular need humility, and to say, I am not here to build, as Justice Antonin Scalia said, I'm not here to build the good society. I'm here to do my very best to set aside my personal views, my personal predilections, and to simply do my very best at interpreting these majestic words of the Bill of Rights as we're talking about the first freedom. Now, do they always succeed? Of course not. We all sin and fall short of the glory of God, as Paul wrote the Romans and the Church at Rome. And so too the judges in the secular sense just can't get past their own life experiences. I recall very vividly the issue of, at the time, it was a very, very hot issue, no metaphor intended, but that was the flag burning cases that I was privileged to argue the second round of that. And two of the justices who ruled in favor of protecting the flag just said, in effect, I know this is First Amendment expression, but as a veteran of World War II, or Korea as the case may be, Justice Stevens, World War II, Justice Rehnquist became Chief Justice of the Korean War, I can't abide by that. You just cannot burn this flag. So it's not a criticism. It's just a fact that their views were so deeply held as citizens that they could not leave that, as it were, at the courthouse door. But that's what judges should try to do, to divorce themselves from the culture and to be true to the law, the Constitution, and the laws of the United States. Easier said than done.
So follow-up to that. Do you think it is oftentimes the citizens' general belief that the justices are, in the words of Judge Scalia, to build the good society?
Yes.
They look at the court and say, no, that is the job of the court.
Yes. I think there's a profound misunderstanding about what the role of federal judges is. They are not family court judges. What's in the best interest of this child? What's in the best interest of this couple? No, they are there to say, what do these words mean in light of our history and tradition? What does the First Amendment mean? What does the Fourth Amendment mean? And so forth. So I think that there is a misunderstanding what the job description is. Sandra Day O'Connor, before she stepped down a number of years ago from the Supreme Court, said in a very poignant way, as I give presentations around the country to citizens groups and so forth, I believe that there's been a collapse of civic education in the United States. Well, there may be other collapses as well, but a collapse in civic education is a very serious thing for a democratic republic where the Constitution speaks not we the states, we the people. And so part of the reason I wanted to write the book, Mark, was that I felt that there had been a collapse, or certainly an erosion in understanding of some of these great principles that protect our fundamental liberties.
So when I go after my family member who did exceptionally well in school but didn't have much interest in history or government, he needs to be scolded a little more.
Encouraged. Encouraged. The Apostle Paul would say encouraged.
Encouraged.
Yeah.
If I could speak to
Sure.
that also just very briefly as well, one of the reasons I don't mean to sound patronizing, but so grateful for Judge Starr and for his entire career is the degree to which he just articulated a judicial philosophy that I would wish Christian leaders understood more fully, and that is that the job of the judges is not to make the laws, but to interpret them. We have a Congress to make the laws. We have a judicial system to hold those laws in review relative to constitutional expectations and alignments. And it's when justices discover laws in the Constitution that didn't exist, when they themselves are functioning as a judiciary or legislative rather than judiciary arm, that I think we get into such difficulty and challenges as a nation. And I say that to my fellow evangelical leaders who would like the justices on occasion to legislate morality for us, who would like to come to them and be so frustrated when they won't take our side on what is right or wrong, when their job is to make a decision based on what the Constitution says and what it means by what it says. The analogy there is for us as pastors. I used to tell my students, the only word God is obligated to bless is His word. I love something that Fee and Stewart said in their book, How to Study the Bible for All It's Worth. They said the Bible can never mean what it never meant. Our question is to ask, what does the text say, and what does it mean to say by what it says, and how do we apply that intended meaning to our lives? In that sense, those that see the Constitution as a living document that must constantly be updated, must constantly be revised in the light of changing trajectories in the culture and the personal beliefs of the justices, are in so many ways, I think, tragically misunderstanding the various separations of powers that the founders intended. And we pastors have to understand that as well, and pray for them as they're executing their responsibilities to do so according to what the Constitution means to say, not what I wish it said or what I wish the justices would agree with me is right. And that's, I think, a significant understanding that a lot of us could do better toward.
Yeah, I think so too, because there seems to be in some of the conversations I get to be a part of at times that we almost look at the three branches of our government, and we typically tend to look at the justices in the Supreme Court almost as our ultimate parents. And we're going to bring our problems, our conflicts, our issues to them, and they are the final ruling best parents we have. And they're going to settle this, which kind of brings me into one of the things I wanted to ask you about, Judge Starr, which is in just the last couple of years, for the first time in my 58 years, I've watched two movies about one justice. We've seen in the last 5 or 6 years the celebrity status of the now late Ruth Bader Ginsburg. Part of the documentary I watched about her life talked about what many would consider to be her misstep when she criticized President Trump as a candidate. But two movies, two full-length feature movies about one justice. Do you think we have drifted to the point where there is too much emphasis on the judiciary, too much emphasis on the court, and perhaps not enough, I heard another commentator make this statement recently, that the Congress is supposed to be the most powerful branch of the government, and we have lost sight of that in favor of the more celebrity, powerful status of the president and perhaps the celebrity and power status of the court?
And the power celebrity status of the court is quite new. Justices didn't go around giving speeches and interviews and the like. In the main, I do recall many years ago, this will show that it was decades ago, Justice Hugo Black, giving an interview to Eric Severide of CBS. And it didn't seem inappropriate because they weren't talking about specific cases, but it was just unusual. But now they are celebrities, and I think that can be carried to excess. Obviously, the lionization of Ruth Bader Ginsburg was in the context of a culture that tended to agree with her decisions, right, and to set its face against the more, shall I say, traditional decisions that were coming down from the Supreme Court during her tenure. And that included religious liberty. But the good news is that, as I said, using the example of the Hosanna Tabor, but there are others, there are often times that Ruth Bader Ginsburg, the most liberal, the notorious RBG, is one of the movies had it, was a great friend of religious freedom. Not always, not invariably. But I do agree, we should not be lionizing the justices and putting them up on pedestals, and I don't think they should be trying to climb a pedestal either.
Jim, is that a reflection of our culture, like the lionization of RGB? How do you see that? Is that part of what's going on in the shift of our culture? We seem to always be looking for another celebrity or another celebrity group.
Yeah, I think it's on two levels. Yuval Levin makes the, I think, very significant point that there was a day when institutions formed the character of those that worked within them and even that led them. My father-in-law spent his entire career at IBM. There was the IBM way. Even went to the white shirts and the ties that one would wear as part of one's code of conduct and code of uniform each day. And so you didn't have celebrity CEOs. No one really knew who the president of General Motors was or who the CEO of Xerox might be or whatnot. And now, as Levin makes the point, it's all shifted to the place now where corporations are platforms for personal celebrity. Whether it was Steve Jobs or Tim Cook at Apple, whether it was Jeff Bezos at Amazon or whatnot, now we're at a place where we're seeing these CEOs or these justices or these leaders as celebrities with platforms on a level that wasn't the case before. And that's because of the other issue that comes to bear as well, and that is the proliferation of social media, where now for the first time, my cell phone makes me a publisher. It gives me an ability to go viral to the world if I wish to do so. And so now I come to corporations expecting them to be a platform for my mission, for my advancement, for my purposes. And I wish celebrity that's going to be built on that platform that I've come to work with and for. And so the culture's gotten to this place where whether it's actors or it's artists or it's athletes or it's justices, we're a celebrity-dominated culture. People are famous just for being famous, as we say, and could have never imagined in previous generations. You simply didn't have access to that. To pick on the Kardashians for a moment, I don't know what they've done that a previous generation's editor would consider publishable or would have considered worthy of being covered in some television outlet or some radio outlet, but now famous for being famous, get you to this place of celebrity for the sake of celebrity. So now we start assigning this to individuals, whether they're seeking it themselves or not, because based on social media and based on platform expressions and personal advancement, in many ways, it goes back to Genesis 3, we will be our own God, knowing good and evil. Nietzsche said the will to power is the basic drive in human nature. I believe that's true. Not for me, certainly. I'm certainly not troubled by that. I am exempt from that, Mark. I want you to know that. My next book will be Humility and How I Perfected It.
Right,
That's
exactly.
my next book.
No.
But for everybody else out there, I would say this is a constant, perennial source of temptation.
And we're grappling in the advent of technology to understand what celebrity does to a person and what the opportunity of platform, regardless of where it is, whether it's in the church, religion, whether it's in politics, government, entertainment, what celebrity actually does to people when they have access in that way. Judge Starr, I wanted to ask you to take me to your classroom for a few minutes based on your book and our audience as well before we finish up. A couple of terms that were really key as I read through the book that I think would be helpful for our people to understand better. One of them is the simple word accommodation, which sounds in legal terms, and particularly when we're hearing reports coming out of the Supreme Court about religious liberty and other things, it sounds like we're making an allowance for you. But that's not what the word accommodation means in this case, is it?
It means, to the contrary, respect for liberty and the exercise of liberty, that the government should, in fact, be so respectful of religious liberty and its exercise. After all, we're talking about the exercise of religious liberty, not just the freedom to believe. How can you interfere with someone's freedom to believe? You can imagine, perhaps, if you requiring someone to take a particular oath or a statement of fealty to the state or what have you. The Supreme Court has said, no, that can't be a condition for holding any office of trust in the United States or of the states for that matter. But I think that what we're getting at with accommodation is derived from a wonderful statement by Justice William O. Douglas, one of the most liberal members of the Supreme Court in the 20th century. He wrote this: "We are a religious people whose institutions presuppose a supreme being." So think of the words of the Declaration of Independence. We see exactly what he's talking about. We see the visions of General Washington, of John Adams, and even the somewhat eccentric in this area, Thomas Jefferson, who nonetheless attended worship services in the Capitol faithfully on Sundays when he was in the Capitol and not at Monticello. The idea of accommodation really means respect, that we are going to respect your vision, respect the religious motivation and philosophy that animates you, we being the government. So to use the example of military chapels, why do we have chapels and paid chaplains and so on? The idea is we want to accommodate, not be hostile to religious expression. The idea of separation doesn't mean hostility. It means rather what one justice called a very benign neutrality. You shouldn't be taking sides. I'm for the Baptists, I'm for the Catholics, I'm for the Muslims. No. All are equal under the law, but at least government has this obligation as a constitutional matter to provide essentially refuge, safe haven. It should not be called into question, as it sometimes is, when it does seek to have this kind of accommodation. And by the way, Congress agrees with that. Sometimes we overlook the fact that Congress, just as an institution, I'm not talking about a particular Congress, can be a great protector of religious liberty. We talked about the Religious Freedom Restoration Act and the implications for that by the Equality Act. Well, Title VII, which is a very important protection for employment, against employment discrimination, the 1964 Civil Rights Act, this landmark provision, provides for the accommodation of religious expression, religious views, and so forth. So it's part of our tradition. I would just call it respect for our constitutional traditions and the culture of our people historically, a religious people whose institutions presuppose a supreme being.
Right. Okay. One more term and one more concept, which is I've run recently oftentimes into the term stare decisis and the tendency or lack of tendency of the court, particularly the Supreme Court, to change its mind. I believe your book, you noted that the court has overturned itself 200 times, which was an astounding number to me. Has obviously reference and regard to a lot of our thoughts, feelings, and likely hopes among the Christian community relative to Roe versus Wade. Help us understand a little bit, coming out of your book and your understanding, what stare decisis is, the court's reluctance in some ways to change its mind, but then its willingness to change its mind, and perhaps how that sets a stage for what may happen with Roe versus Wade.
Stare decisis. It has been decided. Stay the course.
Like a parent who says, I made up my mind and I'm not changing it, no matter what the facts might be.
What is it about no you don't understand? I said no. And so the Supreme Court of the United States said, well, we decided that issue. Well, you were deciding the issue perhaps on the basis of a misunderstanding of what the Constitution rightly interpreted means. My favorite example comes from World War II. The Supreme Court of the United States, in a case coming out of Pennsylvania, held that the Commonwealth of Pennsylvania could require precious little school children to salute the flag. We would call it the Pledge of Allegiance these days. 3 years later, the Supreme Court reversed that ruling and said, we were wrong. Now, was it because the court had changed dramatically in personnel? No. Some of the folks who had been there for the Pennsylvania case were still there, and they were in dissent, saying, no, this is wrong. The state should be able to require little children to participate in this. Now, why did the Supreme Court reverse itself only 3 years later? Because we got it wrong. We violated, I'm paraphrasing here, freedom of conscience. Those little school children have, as human beings, the right to come to their own views of right and wrong. They're not hurting anyone. There's no harm, the Do No Harm Act that we might talk about. And therefore, we protect that fundamental ability of human beings to come to their own views about what is precious to them, what's important, where do their loyalties lie, and so forth. And the Supreme Court of the United States is, I'm so glad you mentioned that, over 200 times come exactly to that view. And so you're exactly right as well. That is an issue in the Dobbs case, the Mississippi abortion case, pending before the court. It was argued December 1. We shall see. And it struck me from just listening, as I did, to the entirety of the oral argument, that a majority, it's not going to be unanimous, but a majority of the court seemed to be of the view that we need to maintain an open mind and be willing to reconsider. Stare decisis says stay the course, but your oath to the Constitution means you need to maintain that open mind because your predecessors may have gotten the decision wrong.
That's helpful. And also hopeful, which is kind of the last word where I'd like us to end, which is your confidence about religious liberty and your confidence particularly as it relates to the Supreme Court. There's been these ideas floating around about packing the court, imposing term limits. What is your view about those kinds of ideas? Are you in favor of them? What is your overall perspective, hopefully, about the court and about religious liberty in broad terms?
I'm both hopeful, and I think I'm being realistic at a political level in saying the court is going to maintain its current structure. Even though there will be proposals, and there have been proposals, including the President Biden's commission that took a very careful look at the Supreme Court's work, but it did not come forward with a recommendation that we need to, quote, pack the court. The court has had its current number since 1869. Interestingly enough, that number is not carved into stone. It is not in the Constitution. Congress does have the authority, if the president approves, to change the number. And there have been serious proposals to say, let's add as many as 4 justices to the Supreme Court. I think as a political matter, they will go nowhere because just as FDR discovered in the 1930s, when he was coming off of a landslide election in 1936 and was so frustrated by what the court was doing and tearing asunder so many of the programs of the New Deal, decision after decision after decision. And so I can imagine FDR saying, I'm fed up. I'm going to do something about it. So he proposed a court packing plan that was dead on arrival on Capitol Hill. Even though his party so dominated both houses of Congress, overwhelming re-election in 36, they said no. And I think that same sentiment of stability, we want to disagree perhaps with the court, the culture might be saying, but we nonetheless want to protect its integrity and its structure. So I'm very optimistic about that.
Well, we appreciate all of your thoughts and contributions today. Jim as well, thank you both for being a part of this conversation. It's been fascinating. We look forward to hearing more from you as well in writing and in other opportunities. Judge Starr, thank you for being here. And Jim, thank you for being a part of our conversation today.
It's a privilege for me. I'm so glad to be able to do this with the judge. I've been an admirer and a fan for so very, very many years. And I just want to say, at the risk of sounding patronizing, that I believe we need more models like Judge Starr who can evidence what it is to be an James Davison Hunter, we talk about this so often, his book, To Change the World, demonstrates you change culture by achieving your highest place of influence and living there faithfully. Calls it manifesting faithful presence. So you pay the price to achieve a place of excellence in the culture. You discharge that responsibility with excellence. You do so with a winsome spirit that's speaking the truth in love, manifesting the fruit of the Spirit. You're being salt and light, and you're planting trees you'll never sit under. You're shifting the culture. You're making a difference that you can see and that you can't see, and that you're ultimately trusting God with. Well, that's what the judge has done with his entire career. That's an example of the fact it can be done. And we need people to do exactly what he has done, what he and Alice have demonstrated, I think, to the rest of us. And that's why it's such an honor to be in this conversation and to hold him up as an example as we seek to go forward to build more people who will use their influence to shape the culture for the glory of God.
Well, thank you both, but the honor is truly mine, and especially to be with this very humble Dr. Denison. I'm just overwhelmed with his humility and his happy recognition of that.
That will be my
humility.
next book. As
That's
I
right.
said. That's right.
That's right.
I've already perfected humility, so now I just need to write the book.
That's right. That's right.
The book will be
It's
as
a-
perfect as the concept.
Yeah, it reminds me of the old song. It's hard to be humble when you're perfect in every way.
It is. It's a
That's
challenge.
Right. That's right. Only in
But
Texas.
thank you. In all seriousness, it's been an honor and a privilege. So thank you both.
Thank you. And thank you to all of you who are listening to this podcast. We hope that it's been helpful to you. We'd encourage you to send your responses, to rate us on your favorite podcast app. And we hope that you'll share this with others and let them be a part of the conversation with us. Thank you.